Welcome to our AXS Law Group webinar series. We will be doing these the last Wednesday of every month on a go-forward basis. So hope to see some of these names again and hopefully some new ones. My name is Morgan Geller. I am going to be moderating our esteemed panel of my colleagues at AXS Law Group. I am joined by Lauren Forenza. Say hi, Lauren. Hello. Andrew Fromer, Ben Walkoff, and Jeremy Ben David. Our firm is a boutique full-service law firm located in Wynwood. We're a group of 13 lawyers, and we practice corporate and business law, hospitality law, real estate and franchise law, and commercial litigation. We are all part of the corporate transactional group, so we hope that you guys enjoy our presentation today. It's going to be more of an informal format compared to some of our previous ones, so you will see how us lawyers work together in our natural habitat. Again, to the group, feel free to interrupt and talk over one another. It'll make for a very good conversation. And for those of you who are attending, if you do have questions during the presentation, there is a Q&A button at the bottom of the Zoom screen. So if you type the questions as you think of them, we will get to the end of them with time permitting. And lastly, some required legalese. What you will hear today should not be construed as legal advice and is simply for educational and informational purposes only. So what we are going to cover is a product of the questions that were submitted, as well as some timely topics as things stand today with the coronavirus and governmental updates. So what we're going to cover today is kind of the issues that businesses are thinking about now as we look to see what our new normal will look like. So the first topic that we're going to cover is going to be relating to the Federal CARES Act and the Paycheck Protection Program, because this has been a topic that is can be quite technical. And the first question is for Jeremy. So the question is it too late to apply for PPP funds? And again, PPP is Paycheck Protection Program, PPP funds, and how do I go about doing so?
Sure. So, hey, everybody. The short answer is no, it's not too late to apply. The longer answer is you better get to it. It is a pretty competitive process. Funds are issued on a first-come, first-served basis. They're not unlimited. I'm sure as many of you have heard that Congress and the president recently signed into law an extended stimulus package, which increased the amount of funds available for the PPP program. So it is not too late, but if you are still interested in applying, you should hurry up and get your application in. The second part was how do you go about doing it? So the loans are funded through you're basically whoever your banker is. You can go to any bank and you can apply for the loans through your bank. You don't have to apply through the SBA. You just can go to whether it's a local bank or a national bank. Go to your bank, fill out an application. Be prepared to have all of your payroll information ready, your health insurance payments ready if you're the employer, W-2s, W-3s, 940s, all the backup information that may be required. Have that handy as well, for your application, because you will need it. And like I said earlier, the sooner you do it, the better, and the more likely you'll get funded.
Jeremy, in the spirit of making this dynamic, so what would you suggest to someone who's having a hard time with their existing bank, right? Let's say your bank, your bank with Bank of America we know that Bank of America is doing a terrible job by all accounts in
Yeah.
processing applications. What would you do?
Cross your fingers. No, unfortunately, what I've noticed is that some of the national banks, Bank of America, Wells Fargo, the bigger banks, are really giving preference to not only existing clients, but clients that do have substantial funds with them or an existing loan with them. If you can't get to a Bank of America, Chase, or Wells Fargo, maybe approach one of your local community banks and apply through them. There are also some online lenders that are doing this as well. Kabbage, Kabbage is one. I think Lendio is doing it as well. So you may want to look to some of these online lending institutions, to apply that. If you can't get, FaceTime with a Bank of America or Chase or Wells Fargo, for example. We did have a quick question that popped up in the chat about whether you need to have your 2019 taxes filed yet. The answer is no, you don't have to have them filed yet to apply for a PPP loan. The 2019 taxes, the due date of April 15th has been extended. So you don't need to have them filed yet, but if you do have them, at least in final draft form, that will help. In order to apply for your for the PPP loan, they'll either look at your trailing 12 months of information or your 2019 calendar year information. But it's not a requirement to necessarily have your taxes filed yet, but it does, if you do have it filed or do have a final draft form, it does help complete the picture when you are applying.
Do you guys have any clients that use any of the online lenders? And if so, what was that process like? Because I've had some people inquire about Kabbage, and I'm curious to know what your feedback is, if any.
Yeah, so I did have a client who have used Kabbage, for example, and the process, from what I've told, was pretty easy, pretty simple, user friendly.
Yeah.
The downside with an online lender is sometimes if you have questions or if you have a unusual circumstance that needs interpretation, or you want to speak to somebody, you just may not get that touch, that white glove service that you would get by speaking to a banker at a retail branch. But in terms of the process itself, the feedback I've received has been pretty favorable. In terms of applying to an online lender and that actual process.
All right. We have another question that just came in regarding PPP. Benza Brett asks, it's still unclear that if you pay your staff on a 1099 basis, if that qualifies. Can you please address that for PPP?
Yeah,
it's really clear. You cannot use your 1099 independent contractors in calculating your PPP loans. This was, I know Jeremy and I, you and I, we had like 2-3 days of discussions in actually reading the law when it came out, because technically speaking, if you read the law, you should be able to include your independent contractors. But the SBA, which has the authority effectively to interpret the law, came out and shut that down real quick. So it's gotta be, W-2 payroll employees, either directly your payroll, or if you're going through a PEO, you can then use the PEO and payroll. PEO.
I think the reason for that is now they're saying that independent contractors can actually apply for a PPP loan themselves, and so that's
exactly. So when you're calculating your payroll costs, you can't include 1099 independent contractors in that calculation. Those folks who are 1099 can apply for their own loan. And I guess there was a follow-up question of whether you could have two applications at the same time. I believe the answer is yeah, you could. You just can't accept funding for the same application from two different banks. So if you want to apply through a few different banks, maybe an online lender, I don't think there's anything wrong with that. You just can't accept the loans if you get funded or approved at the same time.
All right. don't see any other questions, so we're gonna move on. A lot of people have asked, well, what happens in 8 weeks once your funds are used up if you've already received your PPP funds? What are other options, if any?
It's a hard one that we.
Yeah.
Or is just SOL?
Unfortunately, there's no great answer, right? As of now, the PPP loans, first of all, they don't need to be used in 8 weeks, right? I think an important point of clarification here is that the allowable uses of a PPP loan are for payroll, for rent or mortgage, utilities, pre-existing debt obligations. So you can use that money for any of those items. And the reason why the 8 weeks, I think, is stuck in people's head is the amount that's used within the first week of the loan being originated could be forgiven if you meet certain criteria. But if you don't use it in the 8 weeks, that's fine. You can, the term of the loan is, I believe it's 2 years at 1% interest. So it's a pretty favorable loan. It's just the amount that's used in the first 8 weeks can be forgiven, provided no more than 25% is used for non-payroll cost. But I think the broader question is really what happens when you use all that money, whether it's within the first 8 weeks, 10 weeks, 12 weeks. There's no great answer, right? Right now, with respect to the PPP program, there's no additional funding. You may be eligible to get additional financing through the SBA, whether it's an economic injury, disaster loan, some other grants that you can try to get through the SBA. But really, the program isn't right now looking forward, 12 weeks, 16 weeks. It seems that's sort of like a short-term solution.
That being said, though, I think everyone's taking it day by day, and I have even this week heard of things starting to reopen. So not to take away from the fact that it's probably going to be a little slow moving. At least we're looking in the next week or two at some initial reopenings, and so at least we're not looking at a quarantine through those 8 weeks as of now. Just a glimmer of hope.
So Lauren, that was actually a perfect transition into another question that we received. So as things reopen, as we know, restaurants and other companies may not be able to service at full 100% capacity, such as dine-in restaurants may need to have less tables, so there's more space, 6 feet in between the seats. So if a business is not able to open up 100% capacity, but maybe 50% capacity, how does this coincide with the requirement that a company has to accept the PPP loan if they hire back 100% of their employees?
Well, I think this is one of the problems that they didn't and weren't really able to account for with the PPP loan, because that's a lot of the hospitality industry, right? And so unfortunately right now, I don't think that there's any sort of carve out for that. I mean, hopefully if they're going to extend more loans in the future, I have seen that this is a really prevalent issue. So hopefully that would be taken into consideration. Maybe if you could show that you're in one of these industries that's affected that way, they won't have this 100% requirement. But unfortunately right now, that's the case with the current funding.
All right. And, I think a lot of, especially again, in the service industry and some of these lower paying positions, there are some people who have filed for unemployment. They're going to be getting $600 per week on the federal level, plus additional money on the state level. What do you do about people who just say, oh, I'll make some money staying home and that's better than coming to work? Are there any options for a company as an employer? And this is for the floor.
Yeah, well, I'll take the first stab at this, right? So that $600 benefit from the federal government on top of the state's unemployment, there's a limit to that. I believe that ends at the end of August. So it's not forever. For those who live in Florida, unemployment paid by the state, I think is the third or fourth lowest in the country at the max level. So once those federal enhancement of the extra $600 runs out or terminates in a few months, they're back to getting, an unemployed person is back to getting, maybe at max $285 a week. So there's not going to be much incentive for them to stay at home and not work. Furthermore, I think even with folks who are entitled or who are going to be receiving the extra $600 a month or a week for this interim period, it's really hard for people to get unemployment right now. The website's not really working. I think going there in person, people are having trouble to the unemployment office. So it's really problematic. I also do think that from a psychology perspective, the amount of people that are going to stay home and collect this interim period to get that windfall is probably not going to be that much. I think most people do want to get back to work, so they ensure that they have a job during this upcoming recession, possibly get benefits from their company. So I don't think on a percentage basis, the amount of people who are going to sit back on their hands and collect this unemployment over the long-term period is going to be that high.
And I'll just add, it's not like it's a standing offer to come join the company when you feel like it. There's going to be thousands of people looking for jobs out there. So, if there is that exception to the rule where, such and such person wants to stay home and collect that check, I guarantee there's a line out the door to fill whatever role that person's position used to be.
Yeah, that's a good point.
All right. So on the topic of, gray areas, as we know, governments, state, local, there's not a real uniform direction, but we do know that slowly things will start reopening. So one of the questions that we have is, as governments relax restrictions on businesses, am I protected if I just follow the letter of what the government tells me, or should I be taking extra precautions? Also, what are the resources I can consult to make sure I'm following best practices so I can minimize liability?
Is this from an operational perspective, the question?
Yeah, I think so. I'll take a stab at this one. I mean, obviously you're going to want to follow whatever your local, state, and federal government is telling you. As far as above and beyond, for liability purposes, will you be on the hook if you don't take all these extra measures that you maybe should be thinking about? Probably not if it hasn't been ordered by some local authority, but you're going to be want to be taking all of these precautions anyway. You want to create a safe environment for your employees. You're going to want to create a safe environment for people visiting your establishment. Customers are going to want to see you taking extra precautions to make sure that you're making everything clean and enforcing some social distancing. Something that I would recommend, and I think the second part of the question was regarding resources. I was checking out OSHA and the CDC's website a little earlier, and they have some really fantastic publications that they've been updating on a daily basis of a very large number of steps that you can take to make your workplace safe for employees and for guests. So I would just say review those on top of things that you have to follow. And I also think there's a balance between profitability in some of these measures. So I think you're going to really have to look at your business, and some of these things that they're recommending might not be reasonable. Maybe that's why they're not being enforced. But I'd say if you can get away with it without it being a huge limitation on the profitability or operations of your business running smoothly, what's the harm in doing it? Yeah.
I'll just add, it's sort of like a brave new world out there, because, we're talking about this thing, COVID, that, now people are worried that if someone contracts it at their establishment and it creates all this liability, what happens to the business? And let's just look back a year ago. If someone, got the flu at your establishment, I don't think there was anyone ever discussing whether or not you'd be liable, for whatever happened to them as a result of getting sick. So a lot of these issues are sort of taking shape in real time. Not to mention it's so hard to know when you got something and to really put your finger on that aspect of liability. So I think it remains to be seen what happens as it relates to that landscape, but it should be interesting. And, I don't think it should be an impediment for businesses conducting business so long as they're doing as you advise, checking, the CDC's website, OSHA, and putting their best practices in place, and then just doing what they do and going on with business.
Thank you, Andrew. And I think maybe we could probably elaborate on what you just mentioned, but from an employment standpoint, are there any best practices or specific things that a business should do or be aware of to maintain and promote workplace safety to make sure that their employees are also safe and to minimize that exposure?
Yeah, there's certainly, the cleanliness, right? And making sure the employees have access to things that will allow for them to, have, a place to wash their hands and gloves if need be. Obviously, having those adequate supplies is important. And that shows, that the company's putting their best foot forward to make sure that they're limiting perhaps, exposure. It certainly depends on the kind of business you have, right? If you're a supermarket and you feel like, having the folks at the cash register wear gloves is a best practice, then that makes sense, right? If you're a hotel and you feel like, the wave of the future will be putting plexiglass between the check-in counter, to the forward-facing guest, then perhaps, that's another way you could limit exposure. But I think something that I've been reading about as it relates to employees is instilling temperature testing. And for a long time, the ADA really didn't allow that kind of thing to occur, but there has been some guidance from the EEOC that basically says, in short form, based on what's happening, it's permitted so long as it's not invasive. So I think, look, knowing someone's temperature is not dispositive as to whether or not they have COVID. I think we all know, there's a spread that can happen without someone having a 101 temperature. And certainly someone could have a 101 temperature and not have COVID. So I think those practices are continuing to evolve, but I think we'll see some more of that in the future.
So on the topic of temperature testing, there's also been discussion about testing temperature and determining symptoms of customers, guests, and other people apart from employees. Does anyone want to address the legalities involved of those measures?
I think just kind of piggybacking off what Andrew was discussing, I think it's now being seen more frequently and it is permitted. I think the focus now from what I've seen, I've been watching some recordings of like restaurant and hotel groups, and I think now they're a little bit more focused on implementing those measures with employees than protruding that out to the guests, but we are seeing establishments do it. I don't think that it's not illegal to take temperature. And I think you just need to be, if you are going to do that, I think you just need to implement policies for your establishment where this is not being done in any sort of discriminatory manner, right? So if you're going to take the temperature of everyone that's coming, you have to make sure that you're applying it consistently. You can't just see someone that looks like they might be sick or older and decide, oh, that guy looks like he might have COVID. That would open you up to some sort of discrimination claim. So I would just say, make sure if you are going to start using temperature checks, you're making the policies for doing so really clear to all of your employees, and you're applying it in a consistent way.
And I would add, I challenge all employers out there to go through the motions, right? Like, what happens if an employee comes to you and says, I have COVID, what are you going to do, right? So I think walking through the steps in terms of, formulating a company policy, and then figuring out how you're going to assess risk and going through the investigation process and then coming up with communication that you would then provide to, whether it's your vendors, it's your guests, whoever perhaps came in contact with that employee, and then obviously understanding the law, right? Not disclosing the confidentiality of who got sick. So I think, if you're at home right now and you're trying to figure out what this looks like go through all of that and put it on, put it on paper and be ready for when it happens, because it's going to happen. And, you're better off figuring that out now than, in real time.
Thank you, Andrew. I do want to just add to everyone joining us, if we don't get your question right away, it's either because it's maybe on my list and we're going to get to it. And then at the end, to the extent I haven't gotten to any questions, we'll return to them. And then lastly, if we run out of time, all of our email addresses are below our names. So feel free and email any of us if we don't get to your question. So circling back, getting back to the topic of dealing with employees and guests, we have to ask what happens if an employee or a customer refuses to cooperate, does not want to give temperature, or does not want to answer certain questions. What do you do then? Whoever wants to take this.
I can answer it from the employer-employee perspective. My advice is I would not fire the employee if they refuse to, only because there could be other things at play, right? It might not just be not wanting to provide temperature as it relates to COVID. They could have another disability or another reason why it might not be appropriate to take their temperature. So, obviously there's different variables at play. My high level advice would be, I would not terminate the employee because of that. But if you did decide to terminate the employee, I would make it clear that, the reason that he or she is being terminated is because it's affecting the safety of guests and employees, so on and so forth. So it's one of those really gray areas. Erring on the side of caution, I would not.
Great.
And on the flip side with guests, I would think you can take the other position, and what's the purpose of having these tests for your guests in the first place is so that you can make sure that you're making your establishment safe for other guests. So if somebody does have that high temperature, I'd say you're okay in refusing them to come in. Again, just making sure you're doing so consistently across the board and you're not picking and choosing because that can expose you to some liability.
Thanks, Lauren. Does anyone else have anything to add before moving on? No? Okay. So still continuing on the subject matter of guest relations, if you may. And I think we kind of touched upon this in the beginning with Andrew, but what do you do if a guest actually becomes ill while staying at a hotel or, dining at a restaurant? What is the liability in terms of that guest claiming that he got coronavirus at your business's establishment?
I think Andrew kind of touched on this before, but I do think it's going to be very difficult to bring these sorts of claims for a number of reasons. First of all, I think, as we all know, COVID is extremely, extremely contagious. So I think it's going to be very difficult for someone to prove that they contracted the virus at your establishment. Also, I know that there are a number of cases where it takes a number of days for you to even see symptoms. So I think there's the argument that you could have very likely had it before for a period of time and not even known it. I also think that, everywhere is going to be dealing with this issue. And if courts start allowing people to make these types of claims, it's going to open the door for a huge number of claims that are very, very difficult to litigate or to figure out. So I think that it's going to be difficult. On the flip side, though, I was thinking about this for a little while, and there are, of course, going to be exceptions, right? So say you are an employee at a job where you're coming into very close contact with people and COVID has been around for a number of weeks and your employer has not been providing you with masks or given you hand sanitizer or anything of that nature. in that situation, it's obviously a lot different. So I think if there was liability, it's much more likely to.
I'll also.
My mom calling. If you are gonna have liability, it's much more likely to happen in that scenario than just saying, I ate at your restaurant, you know, I'm sick, give me money.
Yeah. And Ben, were you going to add something to that?
I was just going to say, if you're, you know, there's an evidentiary burden proving that you got it somewhere, which I think is what one was talking about. I would say, I would be careful. I'd be more worried if you're in violation or not following local ordinances or local orders, and, you know, keeping your establishment open, you know, in a time where you shouldn't be. I think in those types of situations, there's probably greater exposure because your duty of care is elevated in those types of situations.
Morgan, I'll also add, it depends on what the damages are, right? Like if we're talking about you're a guest and you're submitting your emergency room bill to a restaurant and they submit it to their insurance company and it's $400, maybe they decide that it's just not worth the issue. You know, if you're talking about, you know, the death of someone and perhaps, you know, a legal action, obviously, I think that becomes a little bit more complicated. So obviously there's two ends of the spectrum there, but we could perhaps see some of the de minimis stuff being covered just as a result of the business's insurance covering it.
Correct. And I guess that's a good segue to address the insurance in these scenarios. You know, in everyone's, Ben, you take this one on the topic of insurance. Will insurance cover these types of claims, whether it be, you know, the unfortunate case of a wrongful death or other types of claims involving customers or staff members?
So, you know, the first question is always, do you have coverage, right, for these types of losses? And the second question, if you have coverage, you know, is it, you know, are there exclusions that would apply to exclude, you know, coverage? So, you know, with respect to, you know, there's really only a few types of policies that you kind of reasonably are at play here, right? One is, you know, commercial property insurance, perhaps general, you know, commercial liability insurance policies, maybe an EPL or employer's practices liability insurance policy. The big debate right now, and this applies across sort of the insurance front, is whether or not insurers will cover for anything related to coronavirus, or whether the virus exclusion will apply across the board. And so, you know, it kind of would depend on the context. But the easy answer here is, you know, look at your policies, you know, talk to your brokers, see what coverage you have. If there's a plausible basis for asserting a claim, you should do it, but expect that insurers are going to push back. That's going to kind of be the next wave of you know, of mutually assured destruction. You know, insurers are going to absolutely fight all claims related to coronavirus to the end. You know, so if you have an insurance policy, you think you're covered, you want us to take a look at it, you know, just reach out to us, and either we or other firms that we work with can evaluate whether or not you have a potential claim. And if you're denied coverage, there may be, you know, a basis to sue the insurance companies for their, you know, their failure to honor the policies.
So Ben, should someone first speak with their broker, or should they first speak with the lawyer?
Well, you know, if you've ever read an insurance policy, I mean, even for most lawyers, they're difficult to get through, right? And unless you're specialized in insurance law, you know, it can be difficult. So I would say most brokers probably know their way around a policy, but I wouldn't rely always on brokers. There's no disrespect to the great insurance brokers that are out there, because there are many that, you know, are able to review them better than most lawyers. So, you know, I certainly wouldn't rely on what the insurance company says. They have a vested interest. I would try to get the input from the broker, but I would take that with a grain of salt. And then, if there's any question and you think you might have coverage, and you want a lawyer to look at it, the good news right now is that most law firms that are doing these types of plaintiff's insurance type cases, they're taking them on contingency. So a lot of law firms will look at these policies for you, and they'll know even just by the serial number of the policy and which insurance company we're talking about, whether there's even a basis for a claim, or whether their exclusions based on coronavirus are so broad that there's really no chance. So I would encourage you, if you think that you got a shot, you think you might be covered, reach out to a lawyer, reach out to us. We are looking at some of these claims, and we're also partnering with other law firms as well. So even if we don't do it in-house, we'll find you the right place.
Great. Thanks, Ben. So someone on the topic of insurance, we have a question submitted. Can costs with COVID preparations, as we've been discussing, be claimed as a disaster recovery cost to be covered by insurance? And Jeremy, you decided to answer this live.
Yeah, it goes down to your policy of what disaster recovery costs. I mean, bottom line, and what those preparations are. Nothing with this pandemic and the effects of it is clear in terms of what could be afforded to the insured. As Ben alluded to, there's going to be battles about coverage, whether this was an act of God, whether you had coverage for a pandemic. So there is no clear answer whether COVID preparations could be claimed as a disaster recovery loss, because oftentimes these policies may not have considered a pandemic as opposed to a typical disaster of a hurricane or a tornado or an earthquake. So it'll really come down to your policy. And as Ben stated, I mean, reach out to your broker or, an attorney and that policy and see if there's any coverage there. Or see what their analysis is of that coverage.
Because depending on the business, certainly these costs can be high. Talk about hotels, condos that have to install hand sanitizers by all the doors and elevators, hiring additional staff for cleaning, additional supplies. So apart from insurance, are there any other options that we can maybe explore?
For funding? I mean,
funding?
Yeah, I mean, if you can't go to your insurance carrier, and by the way, that's really just reimbursement, and that'll take a while anyway. Unless there's some government program through the SBA or grants, maybe through a local government authority. There may not be much out there besides coming out of pocket.
I mean, if you're in the healthcare industry and you're providing healthcare services, there's a different bucket of relief available through the recent federal legislation. So that would be the only that besides PPP and besides EIDL, there is a bucket of money there for healthcare, certain healthcare businesses.
I'll just add one thing to Ben's note on business interruption before. It's likely at the moment that these are all going to get denied at the moment, but the important piece is to submit the claim, right? There's language in a lot of these policies that if you don't submit the claim on time, you lose the opportunity to recover. So knowing that the answer from the insurance company today might be denied, it's still really important to submit that claim, get that denial, and at least preserve your opportunity down the road to recover something if the landscape changes and things fall in the favor of the businesses.
And that's where politics comes in as well, right, Andrew? I mean, there the various states that have legislation right now that are trying to require insurers to cover COVID-related losses, even if, by application of the insurance policy, they might not be able to get coverage. That is where perhaps over time, if you preserve your rights, as you say, by filing a claim, the landscape may change in your favor.
Yep.
All right. Before we move on, if a person gets sick on a Miami establishment or I guess Florida establishment, can that company be sued? And we did allude to this fact or this topic earlier. Unfortunately, I always say to clients in the United States, it's very easy to sue someone. If someone alleges that they got sick due to the negligence of the property owner, the negligence of the restaurant hotel, certainly they can sue. But whether or not that lawsuit is successful depends on what we discussed before about the evidentiary burdens and whether or not the insurance will cover it, et cetera, et cetera. So if anyone else has anything to add on that question, chime in. If not, we can move on to the next. Okay. So I think we're going to go a little bit backwards to return to some PPP discussion, because I know that's probably the most significant for a lot of business owners. You know, they want the money to help them, and at the end of the day, these businesses are strongly relying on these funds. So one question that I had initially skipped over in the interest of time, but I will return to it, is my small business is a seasonal business whose activity increases from April to June. And considering that activity from that period would be a more accurate reflection of my business's operations. However, my small business was not fully ramped up on February 15th, 2020, which was the significant date. In this scenario, would I still be eligible for PPP? Ben, do you want to take this one?
Yeah, I can take this one. So I think if I understand the question, there's two issues. The first issue is, am I even eligible because I may not be up and running on February the 15th? And the second is, how do I calculate what I can borrow under PPP? So I guess I'll start with the first one. The first one, and this is born out of the requirement that under PPP, you have to be operating as of February the 15th. So if you're not, let's say you're a seasonal, let's say you're a water park in Michigan, right, randomly. You may not yet be open on February the 15th, it's cold. And so, does that then mean that you don't get to borrow, PPP? And the answer is, luckily, the SBA has you protected, because if you can show that you were operational in the prior year, in 2019, for any 8-week period between May and September, then you're deemed to have been operating as of February the 15th, 2020. So that kind of takes care of that. Now, again, if you weren't in operation in 2019, then you have a bigger problem. Then you probably are not eligible. But if you were operating during that time period, that 8-week period in 2019, you've satisfied the threshold eligibility, issue. As far as what you can borrow, the problem for seasonal employers is that because of the way PPP is calculated, you take kind of a 12-month average of your payroll. And then based on that, you apply 2.5 multiple, and that's what you get to borrow. So the problem with doing an average over 12 months is that most seasonal employers have a bunch of zeros there, right? And so that drags the average down. There's a real downward compression of what you can borrow. So luckily, the SBA sort of contemplated that, and when the law was first passed, the SBA came out with guidance that said that, look, you don't have to use the 12-month trailing period. You can pick a period of time, and initially there were 2 periods of time you could pick. You could either pick the 12-week period beginning February the 15th, 2019, which is a 3-month period. You could pick, basically the 4-month average for the period starting March 1 to June 30th, 2019. If you're the Michigan water park, that probably doesn't help you because you're probably not open until May. And so great, you get to use March or April, but maybe you haven't hired a lot of employees at that point. So in the recent interim guidance, actually came out 2 days ago, the SBA said, well, actually, we'll give you a 3rd window that you can use, and that's any 12-week period between May and September 2019. So if I'm the water park, I pick June, July, and August, or July, August, September. That gives me a good average against which I can then apply the 2.5 multiple.
Thanks, Ben. Another question that is submitted by William Hernandez. Thank you, William. Does waste and recycling services qualify your utilities as something that can be reimbursed under the PPP funding? For the floor.
It should.
Yeah, I mean, at the end of the day, it is a utility, so it should. And I'm presuming, based on the question, that it's referring to services relating to all these additional items causing waste, such as plastics and papers and cleaning supplies and things like that. William, if that does not answer the question, feel free and type an additional question for clarification, but I think the consensus is that it would.
Maybe just a quick reminder as a general principle, remember that you can use no more than 25% of your PPP funds on non-payroll related costs. So
In order for that to be forgiven.
Yeah.
To be forgiven, correct.
Important qualifier, yeah.
Got it. All right, so we've gone through all of our questions that have been submitted and that were addressed today. So I think we're gonna do a little something more on the fly, interesting for our last chunk of this webinar. I'd like to have each of us share with our attendees something that you're currently working on behalf of a client that may be interesting, maybe not as obvious, where you're dealing with something as a result of COVID-19. Whoever wants to go first.
I'll start. For those who don't know me, my practice focuses on corporate law and real estate law, purely transactional in nature. And I've been working with a lot of clients since this pandemic started. In the real estate world, both landlord and tenant, as well as borrowers, of loans, of what they should do. And I'll just touch briefly on this from both sides of the table here. Tenants obviously are looking for ways to either not pay their rent or have deferred rent payments during this period where they're either not operating or operating at severely reduced capacities. The answer whether they have to pay rent or not is pretty nuanced and very fact-specific analysis. But what I've been seeing is mostly landlords are willing to work with their tenants through a short period of either deferring rent, adding it onto the back end of the lease, or spreading it out over a period of time once they get back in business, or having the tenant just pay their pass-through costs now. But in summary, landlords are working with their tenants. May not be exactly what the tenant wants, but also they're not, for the most part, requiring to pay tenants immediately, especially if the business isn't opening. And that's what I'm sort of seeing across the board. And on the landlord side, most of my clients are working with their tenants, and most tenants are also being pretty, so some tenants are just paying as is. And I work with a bunch of borrowers who are looking to renegotiate their loans because they had a slowdown in business or shutdown in business. And the lenders that I've worked with or term sheets that I've seen in terms of loan modifications, lenders are providing some relief to their borrowers. Again, it may not be ideal, it may not be exactly what the borrowers need, but most parties are looking to almost give sort of interim relief, kick the can down the road a bit to see how this plays out. But there is some relief being provided from what I've seen to borrowers. And then a word of advice, if you're a borrower or tenant, when you want to approach your landlord or your lender asking for relief, don't just go out there with your hand out asking for help. Have a plan. Demonstrate why you need the relief, the impact it's had on your business, whether you've opened and then shut, reduced capacity, what's going on, what's your plan to get them back, get payments again, how long you forecast this slowdown happening. Have a plan. Lenders and landlords are much more responsive to an educated tenant or borrower, and somebody just looking for help. But in summary, it seems that parties on both sides of the table, for the most part, are working with each other to get through this in a collaborative fashion.
Great. Ben, do you want to share?
I mean, I've been doing a lot of PPP work, and some of the kind of weird nuances of it. One of the things that comes up is there's these weird affiliation rules. So in order to qualify for PPP, you have to have 500 employees or less, unless you're in certain food service. If you're in the food service industry, maybe everyone's heard about, the Danny Meyer, Shake Shack, and Ruby Tuesdays, and all those guys getting a hard time for taking those funds. But with respect to non-food service businesses, there's these affiliation rules that even if you're a startup and you've got 30 employees, if you've got a venture capital investor or a significant investor, even a strategic investor who has, more than 500 employees, you essentially have their employees attributed to you, which would then mean in that example that you don't get to apply for PPP. If that venture capital firm or strategic investor has a certain level of control over your company, such as being able to prevent a quorum from being convened, or having a veto over certain important decisions. So we're working with a bunch of companies to figure out a workaround on that, and what you can do there is you can actually have the investor, strategic or financial investor, waive all of their rights that would otherwise cause affiliation. The problem there is that a lot of times they're not going to be willing to blanket waive their rights just to help their portfolio company get some additional money, and there can't be any wink wink nudge nudge. As soon as you've gotten your PPP and spent it, we'll then reinstate the the quorum powers. That just won't fly from an SBA perspective. So that's something I've been working on quite a bit.
All right. Thanks, Ben. Lauren, Andrew?
I think just from a general contract sense, it's interesting now, force majeure was always something that you include as boilerplate language, but now it's kind of become a main item that you want to look at, and not just making sure that it's included and it covers a pandemic, but making sure you understand the nature of who it's going to affect more. If your client is in the position of delivering goods or a certain service where they might run into problems, then you're going to want to make sure you're making that provision drafted more favorable to the position that your client's in. So that's just been an interesting nuance.
And then I think it'll be interesting to see how these force majeure clauses change in the future as companies go back to their form contracts and reconsider what they actually mean.
And to see how they evolve, because right now we're just seeing really broad language addressing pandemic, but it's okay, who has to make that decision? How long does it have to be in effect for? There's not really a lot of parameters, and I think that's going to make things a little bit messy, but I guess we'll
yeah, and I've actually been dealing with that messiness myself in my practice, which involves mainly franchising. The franchise system usually has their form franchise agreement, but the franchisees are located all across the country. So some franchisees may be under stricter stay-at-home orders, government orders that affect their business different than other franchisees. So you have that dynamic plus, the general interpretation of the contract. And for the franchisor, even if you're contractually still entitled to claim a default or still entitled to collect royalty fees, the better question, I think we've all dealt with this, is, just because the contract says you can at a time like this, should the company still rely on that right? Because there are other reputational factors that come into play. If a large brand starts suing all of its franchisees who are suffering financially, not being able to work as a result of COVID-19, you know, what is that going to look for them in terms of public goodwill? So that should always be a factor as well. And lastly, Andrew, do you want to share with everyone
Yeah, sure.
an anecdote, stories?
I actually had a conversation with a client the other day that has signed a contract for an apartment, and he put down a large down payment, and the closing is set to happen, you know, let's just say the next 4 weeks. So he's trying to figure out, can I get out of this agreement, right? Like whatever my apartment was worth when I bought it is probably not going to be worth, you know, what it's going to be in 3 weeks time. So is there an opportunity to figure out how to get that money back, right? And it's really a practical question. You know, if you put X amount, you know, let's just say $100,000 as a down payment, and you know this becomes litigated, right? I mean, if the attorney fees cost less than 100,000 and you're able to negotiate, you know, a less amount, then whatever you put down, you know, maybe that's the approach you want to take. So I think people are just trying to map out in their head what this new world looks like, and you know, try and be as practical, but at the same time save money, because you know everybody's jobs have changed a little bit and everyone's financial situation has changed a little bit. So you know, I don't think there's an answer to that question. I think at the moment, you know, the courts haven't quite ruled whether COVID would allow you to get out of a contract based on, you know, there being you know, a heightened risk to live in a certain area. Let's call it perhaps New York City. So we'll see what happens, but certainly interesting time, and you know, I think we'll get a little bit more clarity soon.
Hopefully. Thank you, Andrew.
Yeah, I mean, let me just piggyback on that quickly. I mean, a lot of people are trying to get out of deals, and you know, if you're a buyer, all things being equal, right? If you have no other contingencies and you just don't want to pay because you think the value went down, you may not have a great argument, right? Assuming you're past your, you know, inspection or other contingency periods, maybe an appraisal contingency. You know, you may not really have a good standing to sit on, you know, and even if you have a financing contingency, if that's expired, again, you may have a tough time just because the market turned. Unfortunately, it could be tough. You may have some leverage though to speak to the counterparty and say, look, you know, if you don't give me a price reduction, you know, and if your deposit's not great, you're willing to walk away. Realistically, the seller is not going to be able to get a new buyer for quite a long time. The market's not there right now. Yeah. So maybe it's worth it for the seller to give you a small price reduction to get the deal closed. I had a transaction that happened to, right, where we put some pressure that, hey, we'll just walk away from our deposit unless we get a price reduction. Seller was like, sure, because they realized for them to sell this property again, you know, to find a buyer, get under contract, get through diligence, you know, it could be 6-7 months. So they thought it'd be worth it to give a slight price reduction, get the deal closed, you know, hopefully next week.
All right. Thanks. So we are at the hour mark, which is generally we like to keep these informative but still short because we recognize that people still have things to do even though we're all at home. So I do want to thank everyone for attending and submitting your questions. We do record our webinars and we make them available on our firm's website, which is axslawgroup.com, AXS. Our emails are under our names again if you have any questions.
Well,
and was that?
our YouTube channel.
Oh yes, we do have a YouTube channel, thanks to Lauren. And if you are interested in you know, us covering a specific topic, we welcome emails with questions, suggestions, so that we can address your needs, because at the end of the day, we are all in this together and we are here to support you and one another. So thank you everyone, and we'll see you at our next webinar.
Everyone.
Everyone.
Here, see ya.
Bye.